Good morning, Ms. Rivers. Are you able to hear us?
Good morning. Yes, I am.
Great. We're waiting on the defendant. He is, I think, signing a couple things and changing his clothes. And he'll be out here with his lawyers in just a moment, and we'll get started.
Okay, I'm ready.
Great. Mr. Samuel, is your client ready or is he still getting ready? Okay. Okay. I got a, well, I do. I mean, this one's stale then. I'm probably going to get reversed. I'm used to it. Yeah, I mean, good, as long as it's got all that cell phone search stuff in it. So I got a copy of this, which I assume is what you guys are gonna be talking about. Yeah, I did. I mean, there needed to be some, like, a paragraph was in there twice and things like that. But I'm assuming the terms didn't change too much. Okay, and we'll get it all on the record. Okay. I have no idea. Adam will provide what he thinks he needs to provide, given the fact that there's a 700 volume trial transcript on a trial over which I presided, and he can invoke that, and that'll be sufficient. If he wants to do more than just that, it's really his prerogative. Oh, right. No, I remember that more from the Judge Thrash saying, tell me in your own words what you did. Yeah, that's not here. Okay. Okay, for the record.
Oh, and his number.
Okay, I was told otherwise, but here we are.
Sheriff called first.
Yeah. Yeah.
I didn't think it was approved.
Right, exactly. Just you and me on the phone. Right. ASAP. We'll work on that.
He says we can. Yeah, that's what I was asking him. We need to do this. It's today the 22, 23, 24, 26. Security. This is projects to come. Assignments. That's what we need to do. Start filling in the
All right, Ms. Rivers, let's get on the record, please. This is case 17 SC 153902, the state of Georgia versus Claude Lee McIver III. It is the 26th of January, Friday, about 10:40 in the morning. We're here in courtroom 8D. I have got Mr. Abate for the state. We have and Ms. Patel for the state. And then we've got Mr. Samuel and Ms. Clark Palmer present for Mr. McIver, and Mr. McIver is here in court as well. Mr. Samuel, it's my understanding that your client, Mr. McIver, is prepared to change his plea and enter a negotiated plea pursuant to an agreement that you, both you and Ms. Clark Palmer and Mr. McIver have entered along with the state, the terms of which I've had a chance to preview, but we'll get on the record, and that Mr. McIver's preference right now is to proceed by way of that plea agreement in lieu of having the state pursue its appeal of the suppression issue that was recently litigated, ultimately resulting in, regardless of how the Supreme Court rules on that, a second trial in the case involving the death of Mrs. McIver. Is that correct?
Yes, Your Honor.
Okay. For that to work, your client will need to be put under oath by the state. But let me start by pivoting to the state and asking you, Mr. Abate, if there are things you want to put on the record before we start the plea colloquy. I mentioned there is this plea agreement. That's the document I don't typically see. It's perfectly appropriate. So I don't know how you want to navigate that, along with you had a plea questionnaire that I'm assuming Mr. McIver completed. I don't know if you're going over that orally as well. Why don't you let me know how you were envisioning this process going, and then I'll hear from Mr. Samuel again just on process, and then we'll get underway.
Yes, Judge. The state intends to proceed per normal as we typically do a plea. Both the plea agreement and the plea or the waiver of rights form or questionnaire that Mr. McIver went over with his attorneys and signed today would be filed with the courts. But I would go over the normal plea litany as it relates to this defendant.
Okay, I can verify signatures then at the appropriate time, and we'll work off a copy of the indictment in terms of electronic signatures indicating the guilty plea. So I'll cover that part, but you're envisioning, other than there may be witness victim impact testimony, it sounds like there may be someone speaking on behalf of Mr. McIver, and of course, he's free to allocute. But otherwise, format wise, this is a standard plea proceeding.
Yes, Your Honor, and the state intends that there will be 3 victim impact speakers, Mr. William Corey, Miss Danny Jo Carter, and then Miss Elaine Williams.
Great. All right. I look forward to hearing from the 3 of them. Mr. Samuel, anything different from that, or you think that's how we ought to proceed?
Exactly.
Okay, then let's do that. Mr. Abate, are you going to be there? Do you want to be at the witness stand? As long as you're near a microphone, it'll work for Ms. Rivers. Okay. And Mr. Samuel, I am fine having Mr. McIver remain seated if that is easier for him, as long as that microphone is bent towards him and he is audible in his spoken responses. There's no need for him to stand at the podium. Does he have a preference?
So just sit
Just sit
here.
at table.
Okay.
He's going to read.
We'll do that. Okay. Mr.
We just, we've signed the advice of rights form. I can't remember how you do it in this courtroom, but we've signed it, checked everything. So it's already signed. But,
Okay, that's all good. I will go with the flow. I'll make sure it's signed. I'll verify those signatures. It doesn't need to occur in front of me. Mr. McIver, I need to ask you a few questions before Mr. Abate gets started. Are you able to hear me?
Yes, sir. I'll
Great.
stand if you wish.
No, it's not my preference. It's really your ability to get through this process. And if you staying seated there is easier because then you're next to both your lawyers, I'm not troubled by that. It's not going to influence the way this goes down. Mr. McIver, it's important that you let me know, or your lawyers, or the 3 of us, if at any point you cannot hear what is being said, or you are in any way confused by what's said. I don't say that because I think you're someone who gets confused, but because someone may say something that is different from what you thought was going to be the case today. And if you reach that point where things aren't going in the direction you thought they were, I need you to stop us so you can ask your lawyers or me saying, wait, now I'm confused. I thought X was happening or Y was happening. So we can make sure you understand why things are going the way they're going. Does that make sense?
Yes, sir.
And you will let your lawyers or me know if you reach that point.
I will.
All right. Mr. Bate, when you're ready.
Thank you, Judge. Mr. McIver, if you'll raise your right hand, please. Solemnly swear to affirm the testimony about giving the matters pending before this court will be the truth, the whole truth, and nothing but the truth, sir.
Yes, I do.
Okay, you can put your hand down. Could you please state your true, correct, and legal name for the record?
Claude Lee McIver III.
And Mr. McIver, are you at this time or taking or under the influence of any alcohol, drugs, or medicine?
No,
Is there any medication that you take on a daily basis or regularly that you haven't been able to take today that would affect your ability to understand why you're here today?
no.
How old are you, sir, and how far did you go in school?
I beg your pardon?
How old are you and how far did you go in school?
81.
And how far did you go in school? Presumably through law school.
Yeah, I counted it. If you count summers, 20 years.
And sir, are you able to read, write, and understand the English language?
Yes,
You understand that you are charged with the following offenses in indictment number 17 SC 153902. Count 2, felony murder. Count 3, aggravated assault with a deadly weapon. And count 4, possession of a firearm during the commission of a felony.
yes,
Okay, and do you understand that through the negotiations with your counsel in the state, that those counts are being reduced to lesser included offenses that we'll go over shortly?
yes,
So as I understand it, counts 2 and 3 are being reduced. Count 4 remains as is. Is that correct?
That is correct.
Okay.
And Mr. McIver, do you understand you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you may receive a jury trial.
yes,
And have you been able to review the waiver of rights form or the plea questionnaire form with your attorneys, both Mr. Samuel and Ms. Clark Palmer?
Yes,
And do you have any questions about that form that you reviewed with both your counsel?
no,
And do you need any additional time to speak with either one of your attorneys or both of your lawyers about any of the facts and circumstances regarding the plea that's occurring here today?
no,
And are you satisfied with the services that both Mr. Samuel and Ms. Clark Palmer have provided?
yes,
And counsel, do you waive formal reading of the indictment?
Yes,
Do you also waive any and all defects in the indictment, including any with respect to your client's name for the purposes of this plea?
that's correct.
And Mr. McIver, has your attorneys advised you of the minimum and maximum sentence for each charge that you're pleading guilty to?
yes,
That they advised that for the lesser included offense for count 2, which is felony murder, the lesser included offense would be involuntary manslaughter. The minimum is 1 year, the maximum is 10 years.
yes,
They advise for count 3, aggravated assault with a deadly weapon, lesser included offense, which is reckless conduct. The minimum is 1 day, the maximum is 12 months as a misdemeanor charge.
yes,
And lastly, count 4, possession of a firearm during the commission of a felony. Your counsel advised that that is a 5-year, must be a 5-year sentence. It can be, but it can be suspended, probated, or served in prison.
yes,
Do you have any questions about the range for each one of the charges, the range of sentencing for each one of the charges that we just went over here just now?
no,
And do you understand, sir, that this is a non-negotiated plea? Excuse me, this is a negotiated plea of guilty, where both the state and your counsel will make a joint recommendation to the court, but the court does not necessarily have to follow that recommendation and can sentence you as he sees fit.
yes,
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal court, sir?
yes. That's correct.
Yes.
He said yes.
And do you understand, sir, that you waive any and all defenses by entering a plea of guilty here today?
No,
Can you just repeat that question one more
A
time?
little
Mr.
slower, Adam, please.
I apologize. Do you understand that you waive any and all defenses by entering a plea of guilty here today?
yes,
And I'm gonna go over a list of rights, okay? So do you understand that by pleading guilty, you're giving up the following rights? The right to trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or court appointed if you are unable to afford an attorney at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt by the state of Georgia, and the right to appeal if convicted of these charges after trial. Mr. McIver, do you understand that you are waiving or giving up all of those rights by entering a guilty plea here today?
yes,
And has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today, sir?
no,
And is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
yes,
And sir, how do you plead to the charges in 17 SC 153902, count 2, the lesser included offense of felony murder, which is involuntary manslaughter, OCGA 16-5-3?
guilty,
And how do you plead to the lesser included offense of aggravated assault with a deadly weapon, which is reckless conduct? How do you plead to that, sir?
guilty,
And lastly, count 4, possession of a firearm during the commission of a felony. How do you plead to that count, sir?
guilty,
And is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
yes,
And do you understand that you may only have a limited right to appeal this guilty plea conviction? Let me repeat.
Yes.
Yes. And do you understand you have only 4 years from today for a felony charge, and 12 months from today for a misdemeanor charge, to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes,
And as your counsel, both Mr. Samuel and Ms. Clark Palmer, on previous occasions, have been able to go over the process of what a habeas corpus petition is.
yes,
Do you have any questions at this time as it relates to that right to file a habeas corpus petition?
no,
Your Honor, this case haven't been to trial before, Your Honor. For the record, I will give a very, very short factual basis. But had this case proceeded to trial again, the state would have been able to prove that on September 25th of 2016, a little after 10 p.m. at the intersection of Piedmont and 14th Street, here, Atlanta, Georgia, Fulton County, the defendant was seated in his Ford Expedition. He was seated in the back rear passenger seat. He had in his possession a .38 Smith & Wesson revolver. While seated in the back of that vehicle at close range, the trigger, which required 12¼ pounds of pressure to pull the trigger, was fired into the back seat, the front seat, and entered through the back of that seat and into Ms. McIver's back, who was seated in the front passenger seat of that vehicle. It struck her in the back, went through her abdomen, and then she was taken to Emory Hospital, where the life-saving measures that were attempted were unsuccessful, which ultimately the injuries led to her death, Your Honor. Had this case proceeded to trial, again, the state would have been able to prove that beyond a reasonable doubt. The negotiated recommendation that counsel for the defendant, as well as counsel for the state through and with the district attorney of Fulton County, Ms. Bonnie Willis, have been able to come to a negotiated resolution to present to the court as it pertains to count 2 involuntary manslaughter. The sentence would be, well, I'll give you the global sentence and then I can do the breakdown. The global sentence is 15 years to serve, 8 years in prison with the balance to be probated. The first 5 years of probated sentence to be served under home confinement with an ankle monitor and curfew as required in the plea agreement. And then the remaining years just to be served on probation without those additional requirements, Your Honor.
There were in the plea agreement some conditions about no contact with certain people and stay away. Do those remain part of the agreement?
They do, Your Honor, as well as the agreement as part of the plea that the defendant waives certain rights upon entering the plea, and then an agreement as it relates to funds being transferred to other parties related to this matter. And when the court deems appropriate, Mr. Corey, as well as Ms. Carter and Ms. Elaine Williams would like to make an impact statement to the court.
Okay. I need to get on the record because they need to be in the final disposition what the conditions of probation are. I want to make sure I understand them correctly, at least what's been agreed to. I can, of course, add to them, subtract from them, or change them in some way. But as I understand the agreement, Mr. McIver, while on probation, is to have no contact with Mr. or Ms. Carter, so Danny, Joe, and Tom, anyone he knows to be an employee, owner, or officer of U.S. enterprises, also known as Corey companies, with one exception, and that's Mr. Rickert, because of his role as trustee of Ms. McIver's either will or estate. I'm going to use the wrong term because I'm not a probate judge. And Mr. McIver has to stay away from the Corey Center at 225 Corey Center Southeast. Are those all part of what you expect the sentence to be as negotiated by your office?
That is correct, Your Honor.
And Mr. Samuel, are those all conditions you understood to be part of the arrangement?
That is correct.
Okay. And then finally, I'm not going to dive deep into it, but there is an agreement that Mr. McIver has assigned to someone any rights or claims that Mr. McIver would have in the settlement that was paid out in the lawsuit that the administrator of Diane McIver's estate brought against Mr. McIver. So there was a civil litigation, a estate of Ms. McIver against Mr. McIver that was settled for a sum. And Mr. McIver is agreeing that insofar as he has rights to that settlement amount, he is stepping away from that, will make no claim, and it's going to go elsewhere.
We have a signed assignment. We can make it part of the record if you'd like, or we could give it to the Ms. Oliver.
And no, I think as long as this negotiated plea agreement is going to be made part of the record, it need not be part of the final disposition, but it needs to be enforceable should something change. And what the state could point to would be paragraph 2 that indicates that the settlement's going to be supervised by person X for the benefit of persons Y and Z, and that will all, it's all in there.
That's correct.
But the important part is not where it's going, where it's not going. And that is that Mr. McIver is abandoning any claim he might have, colorable or otherwise, to those settlement proceeds.
Exactly right.
Okay. Your understanding as well?
Yes, Your Honor.
Okay. Got it. Then I think I understand the contours. And I am now happy to hear from, you mentioned there were 3 people who wanted to be heard in terms of victim impact. I'd ask them to come to the podium if that's all right, because it'll be rather than, they don't need to, I don't think we need to take sworn testimony from anyone. So if they'll come to the podium one at a time, then Ms. Rivers will be able to hear them. So we can go in whatever order you all want to do this. And if you want Ms. Rolak to read it instead, that's fine too. But I'd ask you to come one at a time to the podium. I know who you are, but the record needs to know who you are. So if you'd introduce yourself as you go.
Good morning, Judge.
Good morning.
Mr. Corey would prefer that I read the statement.
All right. Mr. Corey, thank you for being here.
I am Billy Corey, owner of U.S. Enterprises Incorporated. Diane McIver was with the company for 43 years at the time of her death. She is today missed as much as she was on that tragic day of September 26, 2016. Diane was an intricate part of the everyday operations of all the companies functioning under the umbrella of U.S. Enterprises. Because of her death and its unfortunate timing, it left such a void in the business that several companies were sold. Numerous employees were relocated with other companies, and a small majority of us still carry on the business as usual. There will never be another Diane McIver. Her knowledge and insight into our business operations are missed every day. We carry on remembering that she wore many hats. She was president, a devoted employee, a powerful leader, and most importantly, she was loved and respected. Diane was full of life and should never have been taken away from us in such a careless and malicious way. She deserves justice, and I pray that it will be delivered so that all loved, cared, and respected for her can finally find peace and move on with their lives. It was no accident. One man, one hand, and one bullet ended her life and caused a lifetime of misery and loss for so many others. I simply ask the court today to let justice ring this day for Diane McIver. Thank you for your time.
Thank you, Mr. Corey.
Good morning, Judge.
Good morning. Good to see you.
Good to see you too. First of all, I'd like to concur. I'm Patricia Diane Carter. Patriciadiane. Carter. Almost went with the maiden name. I'm used to that one. I would like to concur with everything that Mr. Corey said about Diane. I didn't add that to my statement today.
That's okay. It's okay to extemporize while you're up here.
Okay. I had a hard time putting words together for today. I'm angry that I have to be here again. My life has been marred since 2016. Losing my best friend in such a violent way and being thrown into a position where I was harassed to make statements to the papers and to lawyers to benefit Texas Story. Watching him sell everything of hers 6 weeks after her death, I could not figure out why. After spending 24 hours on a witness stand and sitting through the trial that lasted over a month, I walked out of that courtroom knowing that there had been no accident. Justice had been served. Then the injustice of being sued for wrongful death alongside a convicted murderer that was serving life sentence in prison was just wrong. And it was all for money. And it was all his fault. They were saying that I was complicit in Diane's death. I have suffered. My career was ruined. I almost lost my marriage. I almost lost my life. I was afraid I'd never get my life back on track. And since October of 2022, this has again become a cancer in my life, hanging over me with impending doom. The stress has been tremendous. I have lost a lot of hair and my sense of well-being. Someone asked me if I was afraid for him to be free. When I answered yes, they said, well, he would be really stupid to do anything to you. And I said, well, he was stupid enough to shoot his wife in the back while I was sitting beside her. I'm just angry. Thank you.
Thank you, Ms. Carter. Appreciate your time.
Thank
you. We have one more.
You're going to read whatever statement you want to read, but you don't have to do anything.
Good morning, Judge.
Good morning. It's good to see you again. I wish it was different circumstances.
Yes, we do.
You want to read?
Sorry.
Can you let the court reporter know who you are, please?
That's what you was just saying.
Good.
I'm Lane Williams. This too is a very hard day. To hear the word guilty after 7 years is completion for a lot of us. However, it brings no resolve. It gives us no peace of mind. But here we are again, and as was stated before, it has been a proven fact that this nightmare for me and my coworkers and all those who love Diane so deeply will never go away. Every day, we're faced with the reality that on the night of September 25th, 2016, all of our lives were changed forever, as well as Mr. McIver's. Many of us employees at the time of her death had been with her over 15 or more years. We were and remain the Corey family, just without her presence and her leadership. The tragedy and lifelong effect of what happened that night changed the trajectory of at least 90% of the staff and employees. Several companies, again, were sold. Some employees were relocated with purchasing companies. Some sought out other employment, but a few experienced employment difficulties because they were just in the training process of their career. Fresh out of college, experiencing an opportunity to grow under the leadership of Diane McIver was all cut short. Lives were changed, careers interrupted, an empty office, a void in our heart, and a vacant chair at the table is all we have to remember our Diane McIver with. There was no gathering of close friends, No memorial service, except the one sponsored by the Corey family. No notice of her cremation. We had to read it and find out about it in the newspaper. She deserved, and we deserve so much better than that. It was and is still a heartbreaking experience. Yet with her being shot in 2016, and even to this very day, though I wanted to believe otherwise, one thing in my mind is still crystal clear. With one gun out of approximately 62, with 12 to 13 pounds of pressure to fire that gun and one silver bullet, I still have never heard the words, "I'm sorry." Nothing has changed, Judge McBurney. She's gone, and now what? Thank you.
Thank you, Ms. Williams.
Your Honor, with that, there's nothing further for the state.
Okay. Mr. Samuel or Ms. Clark Palmer.
We have one witness. You want to hear the witness first, or you want?
However you want to do it. It is now, the microphone has turned to the defense side, so you can present anything and everything you want to discuss.
Okay, are you going to read through the Boykin questions, or was that done sufficiently by Mr. Abadi?
I felt it was done sufficiently by
That's
Mr.
fine.
Abadi, and we have a written version of it as well, the signatures to which I'll verify when
Excellent.
it's my turn.
Okay. Actually, you want to come to the podium, or you want to speak from right there? Actually, you want to speak from here, or you want to come to the
No,
podium? From here?
I was just trying to get.
I just want to know where you want to go.
Yeah.
You want to read from here?
No, why don't you sit down just a minute?
Yeah. 1 second, Your Honor.
Sure. Mr. McIver, when you're ready.
Yes, sir. Thank you. I have to apologize for my hearing at Long Prison, where I was for almost 5 years. All of us, every one of the inmates had COVID at some point, and it took about half my hearing. The bunkmate next to me lost all his hearing. Really rather a shame, but those situations come and go. I wrote Diane's obit. It took me 3 days because I couldn't stop crying for the entire time that obit was there. It's been circulated. It's on the net for time immemorial and so on. So we've had lots of sorries. It should be noted there were 3 memorial services for her, during which time we indicated a great deal of sorrow. 2 of them were hosted by me, one of them in Atlanta and one of them in Texas, with our great many friends are located there. So the record needs to be straight in that regard, because that's the way we did it. At any rate, only thing I can say is that every apology I knew how to perform, and as a lawyer, words are my tools, was to apologize for what had happened, for my actions, not anybody else's, my actions. And I hope that people will certainly understand that in that respect. But I have personally, of course, apologized to all my family members, my friends, my law partners, where I'd spent 46 years. So it was part of my life as well. And we all have done what we can, I think, to at least try to move on from this. It's been difficult, at least, that's for sure. Anyway, I, in starting to wind down as short as I was hoping to make this, I want it to be very, very clear. Diane's the best friend I ever had. And I've had a lot of good friends for a long time. And places where you make friends very quickly, like in war and places like that. But she won my heart quickly. She again was the best friend. She's the best partner I could have possibly imagined. And I will always, always love her in that regard. She died as a result of my actions, plain and simple. I've stood up to that over and over again. I can't remember a day I didn't cry for the first 2 years I was at the prison. It was some standing joke that I ran the law library and they would come in with false series of questions and so on, trying to see if I had any different answers about the way I felt about her and the ways that many of us should. I felt anyway. I can tell you a lot of sad stories going back through the hospital and other places and learning even more about what she had said and done and trying to make it such that everybody, even that didn't know her, would have appreciated what she had. I have worn my wedding ring since the day we were married. I intend to wear it until the day I die. It's a reminder to me each and every day throughout all day that how much she meant to me and she meant to others, and that how no matter anything that I can do can make up for the harm that's been done in that fact. I was troubled as the early administrator of her estate, how quickly claims were filed against her by people she thought she knew extremely well. And nonetheless, we soldiered on and got through that and got those claims settled. And then it came the litigation that you referred to. And luckily we got that done and out of the way. And I hope that now we're at a point where we're not judging each other. We're hopefully forgiving and trying to move on. She's my angel. She waits for me in heaven and I'll be with her one day shortly. And I thank you for your patience.
Thank you, Mr. McIver. Counsel?
Your Honor, we would, obviously ask you to accept the negotiated plea agreement that's been entered in this case. We spent a long time with Mr. Abadi and his colleagues and Ms. Willis as well, talking about the merits of the case and why it should be settled the way it was. I think it is a fair disposition in this case. It was an unintentional homicide, which is reflected in the involuntary manslaughter nature of the charges. The gun was in his lap. His finger ended up on the trigger. The trigger was pulled and it resulted in the death of Diane McIver. As he said, he has accepted responsibility for that conduct since the day it happened, including negotiations back then with the predecessors in the DA's office. So we ask you to accept the recommendation top to bottom, including the sentence of imprisonment. Get credit for the time, as you know, it's in the plea agreement, it's automatic, and with all the conditions of probation, which he will adhere to. Thank you.
Okay.
Oh, we have a witness.
I'm ready for that witness.
Probably should have called the witness before that.
If you have anything you want to say after the witness, I'll give you a closing. Good morning.
Hi, my name is Rachel Stiles. And I first met Diane in the early 80s.
What's your connection to Mr. McIver?
A friend.
Okay.
I was invited to her company picnic, and I see this lady walking around wearing a hat, dressed pretty nicely, and was, making sure everything was being done according to what she had planned. And I said, I want to meet that lady. And being the house manager of the Omni Coliseum for 25 years and arranging different events, I knew we had a lot in common. And our friendship was almost instantly. I first met Tex at a 4th of July party at my cousin's condo there in Buckhead, where Tex resided also. Several years later, Diane bought a condo in that same building. And our paths crossed many times, and often I would assist her with many household duties or, helping her host guests or whatever. When Diane met Tex, I could see a new, happy Diane. She had met someone to her equal. Tex owned a ranch in Eatonton, Georgia, and had horses. And Diane loved to ride horses. In fact, she even owned horses when she lived in Conyers. They fell in love and they shared a lot of the same interests. They spent just about every weekend at the ranch, and Diane would ride the horse. Their love grew, and Tex ultimately proposed to Diane. When they started planning this wedding, Diane, Tex, and she asked me to be her wedding coordinator, and we met every Monday night for 1 year. They wanted this wedding to be something that their friends would always remember. It was a Texas cowboy style wedding. Even the horses were in the wedding. Diane wanted this dream wedding, and Tex wanted to make sure Diane was happy. This never changed. Sometimes Diane would get carried away, and Tex would say, "Now, darling, let's think about this." After the November 5th, 2005 wedding, Tex and Diane were so happy. Diane loved Tex's mom, Miss Winnie. And Miss Winnie treated Diane as if it was her daughter. And there'd be times that Diane would say, "Let's go see Miss Winnie in Texas this weekend." And of course, this made Tex very happy too. In all my years of being around Tex and Diane, I never heard Tex raise his voice to Diane. He would just say, "Darling." They complimented each other in so many ways. The only time that they were ever apart was when they had to travel for business. Diane wanted Tex by her side, and Tex wanted Diane by his side. Tex called me on the morning of September the 26th at 6 a.m. and said, "I'm probably going to need your assistance today." And I was Tex's personal bookkeeper, and we had met with his accountant the week before and gotten all the information we needed for taxes. So I didn't quite understand what he was talking about. Well, the next words out of Tex's mouth was, "Diane is dead." Well, I jumped out of the bed and screamed and said, "What do you mean?" And he said, "I'll explain when you get to the condo." I'm thinking, she either fell off a horse or maybe they were in a car accident. When I got to the condo, Tex hugged me and was crying uncontrollable. He said, "I've lost the love of my life. What am I going to do without Diane?" He spent most of that day in his bedroom, and periodically I would go in and check on him, and he'd be sitting there looking at pictures of he and Diane. When I found out exactly what had happened, I immediately knew this was an accident. And when they arrived at the hospital, Tex never thought he was going to lose Diane. And Diane even told the doctors and nurses this was an accident. Knowing Diane, and outspoken as she has always been, she would have definitely expressed if she thought Diane shot her intentionally. She knew Tex would never harm her. And this is why I have stood by Tex all this time. because I know he is innocent. We all make mistakes, but this is a mistake Tex is going to have to live with the rest of his life. And he's already served enough time for this horrible accident. And he will always love and grieve Diane. Tex has a big heart and is always doing things for people. He was on the board of the Georgia College State University in Milledgeville. And often he would have some of the SAE fraternity boys come and assist them with the different events they would have at the ranch. Tex knew that, college boys could always use a little extra cash. In prison, he would give the prisoners some legal advice. And he oversaw the law library in the prison. He even started a Bible study for the prisoners. If Tex would be released, he could continue using his knowledge and his love for people to help people. Please consider freeing Tex because he has served enough time for this tragic accident. I have always said that Tex McIver was the most honorable and trustworthy man I had ever met. This world could use a lot more good people like Tex McIver. Thank you.
Samuel, anything else?
Nothing further, Your Honor. Thank you.
All right. Well, I want to start by thanking first everyone who is here today to reaffirm their love for and their feelings of loss about Diane McIver. She's not coming back as a result of anything that happens today. She wasn't coming back as a result of the verdict that the jury handed down back in April of 2018. I also want to thank the lawyers on both sides. I know they have worked very hard to reach what they think is an outcome that reflects where we are today. And I think that's what motivates me to agree with the approach these lawyers have taken. In April of 2018, the jury spoke. They found that it was an intentional shooting, not an accidental shooting, but that Mr. McIver did not intend that Diane McIver should have died as a result of the intentional shooting. That was aggravated assault and felony murder. And for many of us, this chapter was closed in this process. It wasn't a happy ending for anyone. Again, it didn't bring Diane McIver back, and it sent Tex McIver to prison for the rest of his natural life. It was a parolable offense, but given his age, that wasn't a likely outcome for him, parole. A lot has changed since then. I think the only 9 people I know of who could conceive of having a loaded gun pointed at your wife's back while you're driving in the middle of the night wouldn't be reckless conduct, determined that this case ought to be retried because there was a possibility that a jury would think that it was perfectly lawful conduct and not reckless to have that loaded gun with your finger on the trigger pointed at your wife's back. And we're back confronted with either a resolution that saves all those witnesses from having to testify again and relive the process, and autopsy photos being displayed across tabloids and television stations and whatnot, and seeking a form of closure that at least means we don't pick at this wound again. It doesn't mean that Mr. McIver spends the rest of his natural life in prison. And for those who seek purely punishment through this process, you're going to be disappointed because that's not how this will move forward. But for those of you who want to preserve your memories and feelings for this bright light that was snuffed out, the vivacious and brilliant businesswoman that Mr. Corey tells us about and Ms. Williams tells us about, if you want to preserve those memories and move forward, I think that this is a healthier and cleaner way to do that than trying this case again. A jury could come back with a not guilty verdict, leaving many people even more upset than they might be now. A jury could come back with a guilty verdict along the terms of this plea agreement, or they could say felony murder again. Those are unknowns, whereas here we have certainty and no further litigation. If you come back into court, it's because you've got other business and not because you're having to relive the tragedy of September 2016. That's not to say that you'll forget. It's not to say that Ms. McIver didn't deserve better than what happened. She did. This shouldn't have happened. Mr. McIver shouldn't have had that loaded gun in his hand with his finger on the trigger. He's the marksman of us. He's the one with the 62 guns, however many it was. He knew better. And I think we'll all go to our graves debating how much of the malevolent intent there was. There was clearly the recklessness. And Mr. McIver, it's certainly not my call as to whether you ever see your angel again. You have much more work to do righting the wrong that you committed. But I think that this resolution that the lawyers on both sides have reached is one that will allow the greatest number of people to move forward as best they can. And I think it strikes the healthiest balance we can strike in terms of deterrence and punishment and allowing people to move forward and not have to relive again and again the tragedy of September of 2016. So, Mr. McIver, I find there is a factual basis for your plea, and that your plea is knowing and voluntary. Voluntary means no one has forced you to enter this plea, but you are entering it because you've decided, after consulting with your lawyers and friends and family members, that it is in your best interest to plead guilty to involuntary manslaughter, reckless conduct, and possession of a firearm during the commission of a felony. Is that a correct perception that I have? That it's a voluntary plea?
That's correct.
Okay. I also find that your plea is knowing, meaning that you've understood all the things we talked about after having had sufficient time to talk with your lawyers about that, and that you are knowingly waiving all the rights that you enjoy as a criminal defendant here in Georgia. Is that also correct?
That's correct.
All right. Then I'll accept your plea that you've tendered today, and as it has been negotiated. You mentioned in response to one of Mr. Abate's questions that you're not taking any medication that affects your ability to understand what's going on, et cetera. I want to drill in a little bit deeper. Are you on any regularly prescribed medication today? In other words, do you take medicine while you're at jail? Morning, night, middle of the day, any medications you take? I don't even know what they are. I just need to know if you take medications.
1 second. Didn't it change? We've been taking something every day, but then it changed Okay, all right.
I'm happy to let your lawyers answer. I just need to be very clear on the record that we don't have a medication interference issue.
So yes, Mr. McIver takes medication, doesn't have anything to do with cognition. It controls other symptoms. But my understanding is the way that it's administered now is it's not on a daily basis. It's done some other way at a less frequent.
Okay.
Anyway, so.
That's great. And my focus, I didn't mean to make it confusing. My focus wasn't on the frequency with which you take it, but whether you are taking medication. I'm going to make it up. You might be on blood pressure medication. Good to know. I just need to make sure that whatever medication you do take, however frequently you take it, doesn't interfere with your ability to understand what we're talking about today. Is that a fair statement?
Yes, sir. And Shakespeare is right. You should always let your lawyer speak for you. But I would say that the only reason I hesitated, I take a prescribed drug called Flomax, and it frankly helps me pee. And that's, I was reluctant to bring that up in such a noble room as this, but.
Well, that's why I wasn't asking you to name the names. Just wanted to understand if what you took was something that caused you to have trouble understanding what we're talking about. It sounds like the answer to that is no, you don't.
No, I don't.
Okay. Mr. Abadi, what steps will the state be taking to withdraw any notice of appeal once this plea is consummated?
Once the plea is consummated, we'll be filing a notice of withdrawal.
All right. Mr. Samuel, the ankle monitor that Mr. McIver will be required to wear, this hasn't been spoken, but I'm assuming it's something he's paying for. There was no mention that it was a county-funded ankle monitor. Is that correct?
That is correct. And I should mention, there's a curfew mentioned in the plea agreement, as we've discussed. It's going to be a 12-hour curfew, whether it's 7 to 7 or 8 to 8, maybe something we work out once he is released.
Sure. I need to start with a window, and I'm going to address the movability of that window. What was in the agreement was 7 to 7. That's not ironclad, meaning it is 12 hours.
Right.
But if it ends up being 8 to 8, 9 to 9, that may be driven by the doctor visits or community service he's performing or whatever. And I'm very open to that.
Thank you.
And I'll get to that.
Okay.
Does the state have any opposition at this point, should it come to light that Mr. McIver is interested in having his probation supervised in another state, if that state approves supervision? In other words, we're not going to need to have a whole hearing because the state says, wait a minute, our understanding was that Mr. McIver would stay put in Georgia.
As long as the conditions remain.
Okay. I wouldn't change anything. The receiving state would need to accept the terms of his sentence. And if that's not something they could supervise, that's a reason why a receiving state says, no, we don't do ankle monitors. So that can't happen. But you don't foresee an issue should I be asked to authorize some transfer of supervision to another state's jurisdiction.
Mayor, Your Honor, that we had many discussions, and it's my understanding that request wasn't likely to be made until a year into the supervision.
Okay, I'm neutral on all that. I just want to think of any issues that might come up so that at least now we're knowing, yes, that will be an issue, or it wouldn't, should it arise. All right. Mr. McIver, you have, I think with you, the original plea, what do we call, what's that document called?
Advice and waiver of rights form.
Okay, you have in front of you the original advice and waiver of rights form. Did you sign that form?
That one.
Yes, I did.
So yes.
Yes, and did you sign it only after your lawyers explained to you everything in that form?
Actually, twice.
Twice is better than once. Mr. Samuel, did you and or Ms. Clark Palmer also sign the advice form?
We both did.
Great. I will take that when we're done and we'll make it part of the record. There is also a negotiated plea agreement that has belt and suspenders. There's a place to sign it on page 4, and then every page is supposed to be initialed. Mr. McIver, have you signed and initialed the negotiated plea agreement?
No,
Not yet.
It's, the terms are contained in the advice form, but we need a separate document if that's what's being filed, but we will sign that. We've reviewed it.
Okay.
Just don't have a signed copy.
I don't need the negotiated plea agreement filed if the state doesn't. It's what needs to be enforced if there are issues. So I assumed there were 2 documents and both would be signed. Mr. Abate, what's your view on the negotiated plea agreement? As it was presented to me in draft form, it sure looked like something that would be signed and initialed and filed so that it is litigatable should there be any issues.
That was the state's understanding. I have an extra copy.
Okay, it's also paragraph 30 of the advice form, but that's
Okay.
fine. We'll sign the.
Let's do both,
That's
just to be safe. So why don't you send that across? And I'll give you all time to sign an initial there. Mr. Abate, do you have any objection to having someone on my staff sign your name on a copy of the indictment indicating Mr. McIver's guilty plea to the 3 counts we dealt with today? All right, Mr. Samuel, can we affix your signature electronically to a copy of the indictment?
Sure.
All right, and Mr. McIver's?
Yes.
All right, we'll do that. I still need to pronounce sentence. I don't want to do that while Mr. McIver is signing.
I'm wondering if reckless conduct is not a lesser included and merges with the involuntary. It has no impact on the sentence ultimately, but sometimes that gets confusing, but
I would agree. It would merge with count.
it merged, so there's no separate.
I think that's correct.
Okay. And you want me to?
If everything's been signed, I need to verify the signatures on the negotiated plea agreement. Mr. McIver, I think you just signed another document labeled the negotiated plea agreement. Does that have your signature on page 4 and your initials on all the pages?
I did not initial the pages.
None of
Okay.
us initialed, but we all signed.
I'm fine with just the signatures. I just saw that there were options for initials as well. Mr. Abate, you've signed the plea agreement as well? All right, I'll staple those and make sure that they get filed. Someone will do that. All right, Mr. McIver, count 1 of the indictment in this case has a not guilty disposition. That's the jury's verdict from April of 2018. Count 2, there was a guilty verdict. The Supreme Court undid that, and you have, and I am accepting, you have entered a guilty verdict to the lesser included offense of involuntary manslaughter, specifically OCGA 16-5-3 subsection A alpha. And I am sentencing you on count 2 to a term of 10 years to serve 8 years with a balance on probation. You will get credit for the time you have served. There are different pieces of it, but anytime you have been in custody in connection with the shooting death of your wife, you'll get credit for those days, whether that's Department of Correction time, Fulton County time, and Ms. Nelson will tote those dates up and certainly share them with your lawyers to make sure we didn't miss anything. You're legally entitled to that. I'm not doing you a favor. I have to do that. But that's part of what was negotiated. So that goes into the 8 years to serve. Count 3, aggravated assault, has been reduced to reckless conduct, which is OCGA 16-5-60. And that is a misdemeanor. I'm not sentencing you on that count because I believe, as do your lawyers and the state, that merges into count 2. Count 4, possession of a firearm during commission of a felony, has to be 5 years and must run consecutive to any counts of conviction, which here would be both count 5, which remains a conviction, but you've already served that sentence. That was the 5 years to serve, and count 2. So it runs consecutive to the 10 years to serve 8. I will probate those 5 years, which leaves you with a total sentence of 15 years to serve 8 in custody with 7 years on probation. The first 5 years of your probation will be served under home confinement, which means you'll have a curfew. That curfew is a 12-hour curfew. Right now, it runs from 7 p.m. to 7 a.m. I am open to adjusting the 12 hours. And by that, I don't mean making it 10 hours or 7 hours. It will be 12 hours unless I receive a motion from both sides saying, let it be less than 12 hours. You've negotiated a 12-hour curfew. What I'm comfortable doing, if there's a good reason to do it, your lawyers would need to say, here's why, making it 8 to 8 or 9 to 9. But it will start at 7 p.m. to 7 a.m. And we will be able to confirm that you are complying with that home confinement because you will be paying for an ankle monitor that will allow us to verify that during that 12-hour window, you don't leave home unless it's an emergency. I don't want you to worry that I'm going to want you back here in court because an ambulance picked you up from your residence at midnight. If you need to go because there's an emergency, you'll go deal with that emergency. I also don't want you to worry that if on one instance you get home at 7:05, you're going to need to come back here. But what will happen is with what we call them ankle monitor violations, the state will be given notice of those. And if they are persistent, that may prompt the state to talk with your lawyers and ultimately to say that we need to have a discussion about whether you are complying with the conditions of probation. So there's not a hair trigger out there, but you need to know that compliance will be monitored. And if there are persistent issues with that, then we either need to adjust the conditions or adjust your approach to the conditions. Does that make sense?
Yes, sir.
Okay. It will also be a special condition of your probation that you have no contact, direct or indirect, with Mr. and Ms. Carter. That means you don't write them or call them or text them, but it also means that you wouldn't put something up online or have someone on your behalf do that is plainly directed towards them. Danny Joe, I'm sorry. Or Danny Joe, how dare you call me a criminal? Anything that would reasonably be perceived as you directing contact towards them through yourself or others would be a violation of that condition, and we need to work through what the consequences would be. You and I both heard what Ms. Carter continues to struggle with, and she's entitled to process that and move forward without you interfering. Similarly, you are to have no contact with anyone who you understand to be employed with, by, or associated with U.S. Enterprises or Corey companies. Obviously, that's Mr. Corey, Ms. Williams, and others, with one exception, and that's Ken Rickert, Rickert. He is someone with whom you may interact because of estate reasons, and you may be doing that through lawyers. That person you could call and it wouldn't be a violation. But if you are in any way directly or indirectly reaching out to Mr. Corey, anyone who works with him or for him, you'll be violating your probation. I would expect Mr. Corey to report that to the state, and they would bring that to my attention. And again, we need to work through the consequences of your violation of the not particularly restrictive conditions of your probation, these no contact provisions. And finally, you're going to need to stay, in terms of restrictions on your mobility or communication, you need to stay away from Corey Center, 225 Corey Center, you know the area, the big smokestack. You have no reason to be there. If for some reason Mr. Rickert needs to meet with you, it's not there. It's somewhere else. But you need to not set foot on that property while you are under sentence. The last condition that I'm aware of that needs to be part of your sentence and will be in the final disposition is that you are forfeiting, waiving, giving up, whatever the right term is. I'm going to say waiving any and all rights that you may have to the settlement from the lawsuit that was brought by the administrator of Diane McIver's estate against you, and a settlement resulted. You are, I guess what I need to say is not that you're waiving, you are assigning the rights that you have, any rights that you may have, you are assigning them to Judge Schwall for the benefit of his two sons, which means you are abandoning and relinquishing the rights you have to that settlement amount. Your assignment is a condition of your probation. You may have already done it, and you'll have complied and completed that term of probation. But that's something you don't get to unwind or undo so long as you are on probation. Do you, Mr. Abate, did I miss any conditions of probation that you had expected and negotiated would be part of this resolution?
No, Your Honor, you covered all of it.
All right, Mr. Samuel, I did not intend to make them any more severe or restrictive than were negotiated. In other words, I am going along with the plea agreement. Did you hear me pronounce these in any way that were inconsistent with what had been negotiated?
No, but I have two short observations. One, I am concerned about the use of the term home confinement, which may lead a probation officer to think that there's some restriction on the window when he's out. And there is no restriction when he's out. He can do volunteer work. He can do whatever he wants to do, essentially, as long as he's home by, well, you know what I mean by that. As long as he's home by the close of the out window.
Let's do this. I'm going to interrupt you. I agree. And so what it's going to say in the final disposition is that it is a special condition of Mr. McIver's probation that he has a 7 p.m. to 7 a.m. curfew.
Correct.
During that window, he must be at home. And that address, of course, must be on record for probation and with the ankle monitoring company.
Right.
But from 7 a.m. to 7 p.m. or whatever that 12-hour window may be, he is going about his business consistent with all the other restrictions we talk about. Don't bother Mr. Corey. Don't be bumping into Miss Carter in the grocery store because that's not your grocery store, it's hers, that kind of thing.
Okay.
So,
The only other observation I'd make is if he is paroled, and there's no guarantee of parole one way or the other. My understanding of the parole board is they will actually let him out under the condition that he starts all conditions of probation, which means if he's paroled, and again, there's nothing in this agreement about parole, but let's say he is paroled with 6 months before the 8 years. For the first 6 months, he will have to wear an ankle monitor pursuant to the parole board's conditions. We've had conversations with Mr. Abadi, they didn't end up in the plea agreement, that would count towards the 5 years of ankle monitoring.
okay. You got that on the record. Mr. McIver, I appreciate both comments from Mr. Samuel. I've addressed the first one. I use the term home confinement. I think I saw it in one of these documents. I didn't make it up, but this isn't classical home confinement. That would be 24 hours. You're not leaving your home, which was one of the ways lawyers were peddling a potential bond for you. We're past that. You have a curfew and you need to be at home during that 12-hour, 7 p.m. to 7 a.m. window. But after that, you will be able to go about your business consistent with your other conditions. You have pled guilty to offenses that are parolable. You were convicted of offenses that were parolable. You didn't get anywhere near your parole window the first time through. But parole is not a guarantee. I just need to make sure you understand that. It may be that the parole board decides in a month, given your age, your lack of criminal history, et cetera, that you should be paroled. But if anyone has promised you that you'll be paroled by day X, I need to disabuse you of the notion that there is certainty about it. There may be a likelihood, and your lawyers are free to talk to you about likelihoods, but you may serve to the day 8 years in custody as a result of the shooting death of your wife. Do you understand that?
Yes, sir.
Okay. You may serve less because you are indeed parole eligible. Once you start parole, the Department of Community Services is now, they do both parole and probation. So these conditions we've talked about kick in immediately. When you leave the custody of the Department of Corrections, you will be subject to these conditions. You may be technically on parole, but you'll have what we call a probation officer. It'll be someone from the Fulton County, if you live in Fulton County, DCS office. So I don't want you to think, well, I did the math. My curfew doesn't start for another 3 months. And so I'm going to go clubbing at night for these first 3 months. Don't do that. You'll be under these conditions the moment you are released from the custody of the Department of Corrections. Does that make sense?
Yes, sir.
Okay. Mr. Samuel, anything else on behalf of Mr. McIver?
No, you've covered it. Thank you, Your Honor.
All right. I want to repeat the thanks to those who have come today to be here on behalf of Ms. McIver. Mr. Corey, my route to work takes me past your smokestack every day, and I've seen you put Ms. McIver's photo up there, seeking justice for her. I respect that, and I understand that. If I had higher powers, I'd do what I could to bring back that person who was clearly the heartbeat of your business operations and the Corey family. And it clearly is a family. It's a business, but it was people who cared about each other beyond the nature of the business. Ms. Williams, I know you've lost someone that isn't coming back. And same with you, Ms. Carter, and everyone else. We don't have that time machine to let me charge the jury on involuntary manslaughter based on lawful act. We don't have that time machine to go back to September of 2016 and say, text, leave the gun in the bag. We can only go forward. I hope you go forward with the love in your hearts for Diane and the positive memories, and allow this chapter to slowly close. The criminal prosecution is over. There are no appellate rights left for Mr. McIver. He can't challenge this sentence later on. The only reason why we would be talking about this case again is because there's an issue on probation. And you all have seen how I dealt with issues on bond. And it would be similar if there are issues on probation. So I wish you all the best as you move forward. And I appreciate you being here on behalf of the one you lost. Thank you. Thank you, counsel.
Just sign this last one.